gun lawyer.
This is Ohio gun lawyer Michael Truman, broadcasting live from the law offices of Barney DeBrosse. I'm the chief associate here in the gun law department. I work directly under Derek DeBrosse. We work side by side on most of these cases, and today we're going to talk about the case of DC versus Heller. So first, with the Heller case, we're going to talk about what gun rights were like before Heller. Then I'm going to talk about how Heller actually arose, and then I'm going to talk about the Heller decision itself. So in the 1970s, the District of Columbia enacted a firearms law that was incredibly restrictive. It said that all firearms had to be registered, but it banned registration of handguns. So essentially, if you were a civilian in the District of Columbia, you could not own any handguns at all. As far as long guns, rifles, and shotguns, you could own them, but they had to be registered, and when they were stored in your home, they had to be completely disassembled, and you had to have a trigger lock on it. So essentially, the gun would be completely worthless for self-defense, because if you needed it, you'd have to put it back together. So in 2002, the Cato Institute, which some of you might be familiar with, it's a libertarian think tank in Washington, D.C., thought that it would be worthwhile to raise a challenge to this law. Their strategy was to recruit a wide range of plaintiffs. They ended up with 6 people, a very diverse group. You had black people, white people, gay people, straight people, all kinds of people, young, old, anyone they could get to advocate for the cause and to show how this injury was affecting so many different kinds of people. One of these people was named Dick Heller. He was a security officer in a federal building in D.C. He was allowed to carry a firearm on the job, but he was not allowed to have that handgun in his home or any place other than the federal building. Interestingly, Mr. Heller was the only person who actually applied to register his handgun, and he knew it would be denied, but he applied anyway, and that ends up becoming important later in our case. So the Heller case began in the Federal District Court in the District of Columbia. This is where generally the lowest federal court where cases begin. In 2003, as I said, all 6 plaintiffs brought suit against the government, alleging that the District of Columbia's law was an unconstitutional violation of their Second Amendment rights. Unfortunately, the court dismissed the complaint, said that there was no constitutional violation. Heller and the other plaintiffs appealed to the D.C. Circuit Court of Appeals. This is one of the major United States Circuit Courts of Appeals that you hear about. You'll hear sometimes about the 9th Circuit, the 6th Circuit. The D.C. Circuit Court of Appeals is one of those circuits. Heller actually prevailed at the D.C. Circuit Court of Appeals. The Court of Appeals ruled on 2 issues in that case. One, they ruled that Heller had standing to appeal. As we mentioned earlier, Heller was the only plaintiff listed who actually applied for a handgun registration. And because he was the only plaintiff to do that, he was the only one who had standing, which means he was the only one who the court said was actually injured. So all the other plaintiffs were dismissed from the case, and Heller remained. That's why we all know the case as Heller. So after Heller prevailed, the government was not happy. They asked the D.C. Court of Appeals for what is called an en banc review. An en banc review is when the entire appellate court of appeals hears the case instead of just a 3-judge panel. This has actually been in the news a little bit recently. Obama's Supreme Court nominee, Merrick Garland, was on the D.C. Court of Appeals at this time. He did not hear the initial case, but on the request for an en banc review, he wanted to review the case. Ultimately, the D.C. Court of Appeals voted to not hear the case. Therefore, the decision of the court that Heller wins was upheld. At that point, the government asked the United States Supreme Court to hear the case. So after the oral argument in 2008, the Supreme Court issued their opinion. It was a very narrow case, the most narrow case that you can have. It was a 5-4 decision. It was authored by Justice Scalia. It's a beautifully written opinion. Dick Heller prevailed in essentially every way. The court for the first time held that the Second Amendment provided an individual right to own firearms, and importantly, it was right outside of the military context. If you read the case, which we recommend that you read, it's long and there's some legalese in it, but Scalia generally writes very well and it's easy to understand, and there's some great analysis in there that we really recommend that you do look at. But essentially, Scalia looked at the history of the Second Amendment and said that it codified a pre-existing right. So essentially, Scalia looked at it like we all look at the Second Amendment, that it codifies our pre-existing right to own firearms. And Scalia applied a very textualist argument to the case, and again, gave a great historical analysis on why the Second Amendment does apply to individuals and not just militias and the military. Ultimately, the handgun ban was struck, as well as the ban on having firearms assembled in your home. One important thing to keep in mind about the Heller case, even though it was a great victory for gun rights advocates, it didn't end the controversy because the case only applied to the federal government and the District of Columbia. It did not apply to the states. That's a little preview of things to come in the next analysis that we're going to talk about.